It is brazen, even by the standards of Team Trump. Attorneys for the ex-president are pushing to dismiss the charges brought by special counsel Jack Smith in the classified documents case. They filed multiple motions last night, 7 in total. One of them argues that the appointment of Jack Smith was unconstitutional. Another one says that Trump had the right to claim that the documents were personal and therefore they no longer belong to the government. Worth remembering that the documents we're talking about contain some of the most sensitive national security secrets imaginable. And Trump kept them in a bathroom, in a basement, in a ballroom even. But arguably, the most brazen of the arguments the ex-president is making in trying to dismiss the classified documents case is this. Attorneys claim that Donald Trump is immune from prosecution because he moved the documents from the White House to Mar-a-Lago while he was president. They say, quote, President Trump's decision to designate records as personal and cause them to be removed from the White House plainly constitutes an official act within the outer perimeter of the president's official duties. President Trump is entitled to immunity for this official act, and that must include immunity from criminal prosecution. Now, this claim sounds familiar. It is because Donald Trump has made that same argument in the federal election case in D.C., an argument that was completely rejected by the D.C. Circuit Court of Appeals. The ex-president is now before the Supreme Court asking for a stay of that decision. On the motions in this case, though, the New York Times reports many appear designed to delay the case from moving toward trial, a strategy that Mr. Trump has pursued in all the criminal proceedings he is facing. So the Donald Trump playbook of delay, delay, delay is now being tested for a judge who has a reputation for being favorable to Donald Trump. As Politico reports, all these motions and 3 others filed under seal must be decided by U.S. District Judge Aileen Cannon, whom Trump nominated in the closing months of his presidency. And that is where we begin this hour with former U.S. Attorney and former Deputy Assistant Attorney General Harry Litman. Also with us, U.S. Politico national correspondent and MSNBC contributor Betsy Woodruff Swan, and former Assistant U.S. Attorney, now an MSNBC legal analyst, Glenn Kirshner. Betsy, is this all just about delay?
There's no doubt that that's a feature and a highlight of the strategy that they're taking here. Of course, they're going to be trying to have a different judicial circuit look at this question of immunity. Obviously, the D.C. Circuit was not particularly sympathetic to Trump, but they're going to, shoot their shot once again in Florida and see how it goes. And, of course, I think the other piece of this that's going to be notable for people tracking the myriad of politically sensitive criminal investigations and processes that have been underway is this issue they're raising of selective and vindictive prosecution. Now, that motion was filed under seal, so we haven't read it. But in one of the motions that did go up last night, there was a reference to Rob Hur's report explaining why Hur did not decide to bring charges against President Biden. What's a bit of a head-scratcher there is that Hur very aggressively pre-butted the extremely predictable argument that he expected Trump to make, that there was a chasmic difference between what Biden did and what Trump did. But, of course, it should be no surprise that the president is likely to be citing that to argue that he's being treated in a way that's very nasty and unfair.
Harry, what did you make of that Hur reference?
Well, look, all of this, and he's been sounding this refrain from the start about selective prosecution in legal terms, really just doesn't hunt. There's a very, very rare channel for making this kind of claim. For the most part, you've just got to stand and have the charges be decided, and then possibly you can bring a separate lawsuit. But I think your watchword is exactly right of delay. In the hands, all of these motions are either recycled, old hat, or just kind of cockamamie. But they're all possibilities that a judge like Cannon could think about and have hearings. They've requested hearings on 5 of them. And really, we could be looking at, 2029 in her hands. So these would be motions that wouldn't really gather much of our attention otherwise, except the judge that they are in front of. And also in front of her, by the way, Alicia, today will be Donald Trump's response in a motion she's granted of his that was really off the reservation. And if she doesn't back down from it, that could be a reason to bring her up to the 11th Circuit. But the big question here is, can she take these pedestrian and meritless motions and make months out of them, as Trump would dearly love her to do?
Glenn, I promise that we will get to the Aileen Cannon of it all, but first I want to play what is now an infamous exchange for you from the hearing on the immunity claim in the D.C. Circuit. Take a listen.
Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes.
I've asked you a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts. And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted? And your answer, your yes or no answer is no.
I believe I said qualified yes if he's impeached and convicted first.
My question was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons, could sell military secrets, could order SEAL Team 6 to assassinate a political rival.
Sale of military secrets strikes me as something that might not be held to be an official act. The sale of pardons is something that's come up historically and was not prosecuted.
Now, what Trump's attorneys are saying in this Dox case, is it different from what they argued here, Glenn?
No. I mean, a claim of absolute presidential immunity is a claim of absolute presidential immunity. And, you know, it really is a laughable argument because the Constitution itself lays it to rest when it says in the impeachment judgment clause, let me translate it from legalese to layman's speak. It says even if a president is impeached, he can still be prosecuted, indeed, for the same conduct that led to him being impeached. So how in the world Trump's lawyers can come up with a claim that the Constitution grants a president absolute immunity in the context of a criminal prosecution is flat out laughable. And I agree with Harry, all of these motions that Donald Trump's lawyers just threw into the mix in Florida, it really is. It's like a house of cards built on a foundation of sand. It couldn't be flimsier. But the question is, what will Judge Cannon do with them, both substantively and on the timing front?
I have another question, Harry, but I want to ask you about sort of one of the gusts of winds that could come and knock that house of cards down, which is if the Supreme Court takes up Trump's immunity claim, right, which is part of what he's trying to argue here, and they reject it, does that then apply to the classified documents case as well?
Yes, so it rejects the claim, but the immunity claim here is even weaker because it was charged very carefully to be about conduct out of office. That's the actual charge Smith did. Unauthorized possession by the former president. He's tried again and again to kind of give it an anchor in the last few hours of his candidacy, and that's precisely the sort of risk that a Cannon could do. Somehow find that that's really what it's about and have hearings to figure out whether that somehow poisons the whole thing. If the Supreme Court says this, the claim is gone, and moreover, the claim should be gone because it doesn't concern presidential conduct. But it would be just in character for the judge to take a long time to get to that conclusion.
Harry, you wanted to jump in and say something else. I want to make sure that you get to it.
That was it.
Oh, perfect. I anticipated where you wanted to go. So, Betsy, in the filing, you had Trump's lawyers mention the proceedings in D.C., and they tell Judge Cannon, quote, this court should not follow the D.C. Circuit's non-binding, poorly reasoned decision. I just wonder how much that ruling actually factors in for Cannon.
There's no question she'll take a look at it, of course, but she's very much demonstrated that she follows her own star when it comes to any number of these
That is a generous way to put it, Betsy.
When it comes to any number of these legal fights that happen in her courtroom. And that's one of the really interesting tensions about the Florida case is that I think most legal experts agree that it's the one that puts the former president in the most intense jeopardy. It's the one where the facts are the most, apparently, as alleged, are the most damning. But at the same time, it's also the case where the judge is as sympathetic as any of the judges hearing these cases. And it just brings a level of unpredictability to the Florida proceedings that kind of distinguish them from some of the other ones.
All right. So, Glenn, we have sorted through the strategy. We have sorted through this question of immunity. Now let's talk about Judge Cannon. What recourse does Jack Smith have if Cannon does, in fact, rule in favor of Trump?
Well, depending on the issue that she rules on, it may give rise to an appeal if it's a case-ending ruling by Judge Cannon. I really do hope at some point Jack Smith believes they've reached critical mass and they have enough to file a motion to recuse her, have her removed from the case, because only if this gets litigated in the full light of day with all of the evidence that tends to support the notion, as is required under the federal law, that her impartiality might reasonably be questioned. It's actually a fairly low standard. If you litigate it and you resolve it, and then you have it go up to the 11th Circuit, and they do, they do full treatment of it, then I think at least we will all know what we're dealing with, and there will be a definitive ruling on whether she should remove herself from the case or be removed, or whether she's qualified to remain on the case. Right now, given these motions, flimsy motions, as I see them, it's a Hail Mary pass. And we just have to hope that Judge Cannon is an honest broker of the law and she's not standing in the opponent's end zone just kind of waiting to catch Trump's Hail Mary pass. That will obviously be a real significant problem.